6:02 a.m. It is September 18th, 2024, and this is the regularly scheduled meeting of the Taxicab Authority of the state of Nevada. We are at 330 West Sahara Avenue, Suite 400 in the Nevada Room, Las Vegas, Nevada. I will call us to order, and the record, Madam Secretary, should reflect that present are members Decker, Graff, Vice Chair Soderberg, and myself, Dan Research Chair. So we have a quorum, and member Graff, would you lead us in the pledge of allegiance?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Secretary, based on the notices and affidavits of posting that have been provided to me, it appears, will you confirm that we've been noticed and posted in accordance with Nevada open meeting law?
Yes.
Our second agenda item is public comment. This matter is placed on our agenda pursuant to Nevada law for the purpose of taking comments from the public on matters within our jurisdiction. We may not take action on any of these matters, but we welcome any member of the public who wishes to address us. Is there any member of the public present in the hearing room in Las Vegas that would wish to bring something to our attention? Seeing none, Madam Secretary, is there anybody online?
No.
There's no online comments, so that will close agenda item 2, our first public comment session. Takes us to agenda item 3, review of the board meeting minutes of August 21, 2024. The board members have received these in advance. I will not be participating because I was not present, but are there any amendments, changes, or additions?
No, I don't have any.
Then the matter's inappropriate for a motion.
So moved. Second.
All those in favor?
Aye.
Aye. Reflecting Lisa abstaining. That takes us to agenda item 4, and this matters on our agenda for industry discussion on matters that are within our jurisdiction that the members of the industry would like to bring to our attention. And we'll open that. Is there any member of the industry that has anything you want to bring to our attention at this point? Administrator Park, anything we need to bring to their attention?
Not at this time, no.
Okay. Close agenda item 5. The next item on our agenda is agenda item 5, which is a public hearing on our initiated proposed future special event surcharges to modify rates. As the board is aware, we've held some pilot programs, and we're now at the point of discussing whether we want to put in place a standing order that would relate to some or all special events. There has been one intervention on this matter, the interventions of the LOA. Is there any objection? I intend to grant the motion for intervention. They have statutory standing. Anybody have a problem with it?
No, no problem.
Okay, the intervention is granted. We do have a draft order which is web prepared, and before we open that up, does the LOA want to make any presentation on this, or are you good?
We haven't seen the draft order, Mr. Chairman.
Pardon?
We have not seen the draft order, Mr. Chairman. We've made presentations on this
Okay.
subject at prior hearings.
Okay. Yes. And okay. So The draft order basically tracks the previous orders. And I'm just going to summarize it and find that there would be a standing order for surcharges on F1 and Electric Daisy Carnival. And then the,
Sorry, Mr. Chair, because this will be key in my comments, I just want to add that also would be included in the order would be other events.
yeah, I was getting ready to,
Okay.
no, go ahead, you may.
Other events considered to be special event, to include a single event less than 5 days in length that unilaterally brings in 200,000 people.
Right. So there is a third bucket, I guess I would say, that is proposed, which is a bucket that would basically find that a special event surcharge of $10 would be added if you had 200,000 or more participants. And as Member Decker indicated, a 5-day duration. And if I'm correct, Ms. Webb, correct me if I summarize this wrong, and a 12-hour preceding and 12-hour following would be the time period.
Correct, that's what it's written in the draft.
So, Mr. Chair, can I just clarify that the LOA's reserve, is their intervention and reservation of their right to either support or oppose? They haven't taken a position? Is that what we're considering?
I think that their intervention, Ms. Rushton can clarify if she wishes, but their intervention was, we don't know what you're going to do, so we want to participate if we want to.
Right. Perfect. Got it.
Be a resource. So again, I'll step back, but that's why we're here. I mean, in response, and if I may, for the record, Kimberly Maxon Rushton with the Liberty Operators Association. Thank you for granting the petition for leave to intervene. But to your specific comment, Member Decker, we were not aware of the specifics of the order, but again, want to participate in the process. And more importantly, just to say thank you to the board for the consideration for developing a schedule for 2025. It's important. I think we've got good statistics that have substantiated the benefit of it. And if there's an opportunity for other special events for us to weigh in on or to come before you and request that surcharge, we'd appreciate that opportunity as well. So thank you. And again, happy to answer any questions.
We had a pilot program, Administrator Park, on March Madness. And it is the staff recommendation, as I understand, not to include March Madness.
That's correct.
Can you just provide us a couple points on why that's your recommendation?
Sure. Probably well, first of all, I want to say that as the administrator, my intention is to get more cabs on the road. That's what I want to see. The surcharge was to get more drivers to drive for cab companies instead of going out and driving for TNCs. So having that in mind, I think that part of the equation, the surcharge helped that. With March Madness, there's no games that were played in Las Vegas for March Madness. It's just strictly people coming in to place bets, which for those people, if we could just pluck those out and give them the surcharge, that'd be great. But my agency received many complaints from people that weren't in Las Vegas for March Madness, and they were getting charged the surcharge, and they didn't understand it, and they didn't like it. We had the second most amount of complaints was from March Madness. F1 was the largest amount of complaints, but that was for all different set of reasons. And because of no games being played here, I I just think that the surcharge probably shouldn't be affecting our riding public that is in town for other reasons. Super Bowl was here this last year. It won't be here next year, so I don't have data to kind of compare that to. I don't know. I know a lot of people come into town to make bets on the Super Bowl. Last year, with the game being here and all the surrounding events, there were a lot more people in town, and I just don't know that we would get that same amount for the Super Bowl as well. Again, I want to just remind everybody that the surcharge is to get drivers driving cabs. I think that was important. I asked Curtis Mell, my management analyst, to kind of take a look at the period of time when the surcharge was on. And one thing that really kind of stood out to me was I think the surcharge was effective, but it kind of drops off halfway through the surcharge. I don't know if that's because people know that there's a surcharge and they don't want to take a more expensive cab ride, or if they're just getting someplace and staying there. But it's really evident that early on in the surcharges, is when it really seems to help. And I know I kind of went off of just the NCAA part, but I wanted to bring that out as well. And I have these graphs if you guys would like to see them on the ridership, if you want me to pass those out.
Yeah, sure.
Okay, I actually have copies.
I think
And
that-
the staff recommendation is to keep the EDC surcharge at the numbers we used this last time.
It is. The EDC event, it works beautifully. I think that's because the event is away from the strip. F1, whole different animal.
Yeah.
The strip is closed down. There is an ingress and egress into the F1 racetrack area. But EDC works great.
There are specific reasons in F1 and EDC why people don't want to drive. Everybody, including cab drivers. So that makes sense.
Yeah.
I don't know, it's March Madness, there's no closures. It's just a volume of people. I think it's interesting though that, I mean, theoretically, if it's going to be a big March Madness weekend, plane tickets went up, hotel prices went up. Makes sense for cab prices to go up because you're handling extra volume, but people will complain about the cab price, but still pay the plane fare, the hotel.
Right.
Yeah.
Mr. Chairman, I have a question. And it, not necessarily weighing in on Mr. Park's presentation, but when I was reading this draft order, I was left kind of feeling I want to know the mechanism. I mean, we've got the two events that are listed in the order, and that's fine. That was laid out very well, and obviously should handle mechanically well. But the other special events with this 200,000 people coming into town, how are we managing that? Walk me through that.
So we get our statistical data from Las Vegas Convention Center of how many people are here. You can have 200,000 people in town if they have 3 or 4 conventions going on, or a Taylor Swift concert and a boxing match. Now, do those deserve surcharges? I don't think they do, because I think I think something like F1 and EDC, it wreaks havoc on the traveling public, where those types of events don't seem to impact the cab industry as much as those two events do. The 200,000 people, my thoughts behind that, we have NFR, which is 10 days long. And that's why we put the 5 days on, because you'll have several 100,000 people coming to NFR, but they may not be staying for the whole 10 days. We're not going to have that many people the full 10 days. So the 200,000 people, we looked at some of the big conventions, some of the big events, and that was the number that I thought was.
That's not, I wasn't questioning the 200,000. I was questioning mechanically, how does this operate? because the order doesn't specify, up to this point, we've been approving specific events. And that's fine, and that was cumbersome, and I know we want to get away from that. But mechanically, how does the industry know today's a surcharge day and not, and how is it uniform? Is this something your office is going to manage and administer and
I,
send out an email? Hey, we got something
So-
that follows a
before you-
special event?
Before you answer, I had the same question.
Sure.
And
So did I.
I'll give an example, a concrete example. So it seems to me when we're doing rate making by order, comparing to the fuel surcharge, I get mechanically how that works. We've said this is the database. When this number is hit, based in that database, you will issue an order. We have delegated to you to issue the order saying fuel surcharge level 1 or fuel surcharge level 2. And then when that statistical database, which we have identified, falls below the threshold, you issue an order saying fuel surcharge is off. To Vice Chair's Dauterberg's point, there's nothing in the order where we've delegated a mechanical method by which you're going to do that. And I'm going to go one step further. I think without that mechanical method, I'm not sure we've discharged our obligation under the rate making by order statute.
Well, I agree, and I think back to Member Soderberg's point, the trigger, if there was any, would be anticipatory anyway. So does that mean if the agency authorizes a surcharge and it turns out that there weren't 200,000 people, is there a penalty?
Yeah.
I think early in the order, it specifically states F1, Super Bowl, March Madness, and EDC. Those are the ones we have experience with. And then later it adds in this third other events category. I'm not comfortable with it. I think we should stick to the ones that we have specific experience with. Otherwise, we're just speculating that you might need the authority to implement a surcharge. And I don't want to go that wide with it. I really don't.
So I'm going to preview. I agree with you. I'm not saying that we shouldn't or can't consider that down the road with some additional statistics. I thought National Final Rodeo would be, I get it's longer and that you have fluctuating membership or attendance, but it might be worthy of being in here. But I share Member Decker's discomfort, and I think perhaps the discomfort you were articulating of not saying these are the specific events. Not because I don't think you could properly discharge a delegated duty. I do believe you can do that, and you do all the time with the fuel surcharge. It's that I think Member Decker's point is well taken. Do we then have a whole bunch of refund requests because there were only 135,000 that show up, but we put the surcharge in place?
Not only that, I don't think we're trying to solve problems that don't exist. I don't know that we have a problem with NFR. We may,
Yeah.
but we may not. We haven't collected any data on it. So why, I wouldn't want to include all those other events until we have experiential data that says.
And I had the same feeling about New Year's Eve or New Year's Day that I have about that as well. It's kind of like March Madness to me. There's no games being played. It's a big event on the Strip, yes, but we've been doing big events on the Strip all the time. So, my inclination is that we approve the form of the order as to F1 and as to EDC, but that we carve out the provisions for these other instances. Not because we shouldn't maybe explore that, but I don't think, as Member Decker points out, and Vice Chair Soderberg, I don't think we have a record before us that supports that.
I would agree with that approach, Mr. Chairman. When we were talking about this, especially when we had the request for an emergency order, I really thought at some point we'd get a plate of events that, based on industry's experience, these are the ones where we're losing drivers. So we need a surcharge. What those events are, I figured we would discuss it. I would assume we would have had an order that laid out all the events, whether it's 10, 20, I don't know. But whatever it was, it would be there. If something else come up, industry would petition us to amend that order or create another order to create a surcharge for some other event that wasn't on the list. It wouldn't be laid in stone, but it would give a full year's template of where we're going with this. And that doesn't create an additional administrative burden on our staff to follow the stats, tell everybody, okay, you're going to get a surcharge on this date. And then you're right. If somebody were to, if we set anything in an order and it doesn't turn out that way, then people are going to, somebody could ask for a refund. I don't know that that would actually happen, but you're right. We're opening ourselves up to a bigger problem. So I'd be more comfortable with seeing a plate of 12 months worth of events, 6 months, preferably 12. And if there's something else that comes up, you know, petition us.
And I think the order as to F1 and EDC, we can proceed with those two events in an order now. We know they're coming.
Mhm.
We know we have great statistical support for that. If we had to, go to court on a challenge of our rate making, I'm perfectly comfortable on those two. We could prevail. I know you have comments, so I'm not going to call anything. So yeah, go for it.
So just to add one thing to the order though, because we don't have the posted notice reference anywhere in the order.
The notice at the airport.
The notice at the airport and the notice in the cabs,
Oh, okay. They know we don't.
that sort of thing, so that needs to be included in, I think, the order. It's part.
When is the next EDC? Is it
May.
May? So we have time. We don't
No,
have
we have F1.
We have
though, in
F1,
November.
yeah.
For F1, we have to act today, don't
February? Or-
No,
No.
F1's in
November.
the first
November.
week of November.
Oh, okay.
First,
All right.
second week.
Because I have another problem.
Okay.
And I know attorneys hate this, but I really think the language needs to be clearer as far as the starting and ending time. And you stated it earlier, you said 12 hours prior to the official start of the event to 12 hours after the official end. That's much clearer than, if you want me to read it, I don't want to.
No,
But it's much clearer than the dates and times specifically that are different for each event. I think it's clearer for us, it's clear for industry, it's going to be clear for the public to say 12 hours before official start of the event and up until 12 hours after.
So did I get did you have other points? Okay. So here's any further discussion?
No, thank you.
Did you want to say something?
Yes, please.
You can come up.
Thank you, Mr. Chairman. Cheryl Gibbons on behalf of Whittlesey Blue Cabin Henderson Taxi.
Before you start though, I'm going to tell them where I'm headed
Okay,
and then that might affect.
okay,
I want you to be able to comment one time.
okay.
So what I'm going to suggest is that we issue an order, we consider issuing an order today that deals with F1, because that's November. And that we come back in a month or whatever with a revised order, and that order not only be, that you take comment from board members one-on-one, not collectively on that draft order. And then once we're comfortable with that draft order, we'll publish it before we have the hearing so that any members of the public. But I think F1, we can issue an order that's consistent with last year and be in position, and then we can deal with the issue. One of the issues, there's a couple of different issues in this draft order. You did a fine job, this way I'm not criticizing, but one of them is start and stop times, and we know that has been a source of complaints.
Right. And just to take it one step further, the order we would consider in a month is the same order, just including EDC, because pending what Cheryl has to say, that's all the agency's recommending at this point. Is that correct?
Yes.
Yeah.
Yeah, and I would like to add, for F1, I think the industry even said that they felt the times were too long on the F1 race last year. So having a clear and defined time limit on those would be very helpful.
Can you, okay.
Well, if it's the board's intention to specifically just issue the F1 order, then I will hold all of my comments until we discuss at the next meeting,
Okay.
when we're going to look at the other events.
I don't know what the motion's going to be. They may surprise me. So I'll let you comment during when we have discussion on the motion if that's not the motion.
Thank you, sir.
What, if you can help refresh our recollection, what was the time periods on F1? New law and order.
Week billet should begin at 1 a.m. on Thursday, and the commencement of the event to noon on Monday, the travel day following the event.
1 a.m. on
1 a.m. on the day before. So
1 a.m. on the day preceding.
yeah, the first practice for F1 is on Thursday, so it would start at 1 a.m. on Thursday,
So that same day.
the same day, yes.
So
We don't
12
know-
hours
We don't know
before,
that date.
I'm sorry?
You just know it's a Thursday. We don't know the date.
Yeah, no, I'm sorry.
Okay.
7 hours before the first event, or how
Yeah,
many hours?
I can look that up. 21.
21,
21st, yeah.
21st of
Of
November.
November.
So it would be 1 a.m. on the 21st,
Yes.
and you would have it come off on
Noon on Monday, which would be,
25th.
25th.
thank you.
But in all other respects, the order that we issued last time would be the form of the order.
Did have industry comments
So-
on the start.
I question those dates. I just looked it up and it looks like the dates for the Las Vegas Grand Prix in 2025 are November 20th through the 22nd.
And we're talking about 24.
24.
We
this
have
month.
one coming up and,
Oh, okay.
okay.
Yes, and that's the 21st. 21st.
And so, sorry, Todd, when does it end? And so I know that the surcharge would end noon on the Monday, but
On
when does?
Monday, the final race starts at 10 o'clock Sunday night.
Okay,
That's when the actual race
10
is. 10 p.m., yeah.
okay.
Didn't we have industry comments on the end time or suggestions on the end time?
Yes.
I thought we did.
And I was also thinking, and I could be wrong, I was thinking that, that the surcharge amount was something that the industry had concerns about also, but I could be mistaken on that.
Well, it was 15.
It is 15, yeah.
So
So here's the thing.
I think
If we're considering this for next month, it still doesn't
2
accomplish.
months,
2 months.
November.
Yeah.
2 months. So for this year, it still isn't what we're asking. We're not asking for each individual event to be requested as it comes. We're still looking for a perpetual
Yeah.
order. So instead of complicating this, why don't we just do that and look at the perpetual order next month or the month after, whenever you guys are going to do it? Because we're trying to do two things at once right now. We're trying to approve a surcharge for F1 specifically this year. Yet we started looking at this from the broad perspective of let's do a kind of a perpetual order. So I suggest we get back to the perpetual order.
If I understand what you're saying is basically tabling the action today and come back next month and approve the standing order, what you're calling perpetual. I don't want to call it,
Sorry,
I don't want to
I'm not a
call it
lawyer.
perpetual.
I'm not a lawyer.
But the standing order and deal with F1 at that time, because we'll still have enough time.
I'm actually suggesting that we deal with F1 today. if
Oh,
we
you are.
can, and then we deal with the standing order next month or the month after, whenever you guys
Right.
get a chance to draft it. Because I think we're trying to do too much. Right now, what's the immediate concern is F1 in the next couple of
Concur.
days. Yeah.
Concur.
Yeah.
I think we should deal with an F1 order today.
Okay.
And then
Get back.
bring
to
it
the
back
standing.
on for a standing order, which will include F1 going forward.
Right.
But at least then the administrator, the agency, and the industry have something, they know what's going to happen with F1.
Right. It gives industry time to look at it, have input, and all of that.
Right. And if we had to amend it, we could amend it next month.
Right. Or the month after, because EDC
Yeah.
is May.
No, I'm talking about F1. If,
Right, right.
if,
Yeah.
if
Sure.
the order that we issue out of today's proceeding is somehow
Right.
efficient in some way, it could be fixed at the October meeting before we actually have to flip the switch for F1.
Right. Agreed.
Okay.
I'm good with that approach, Mr. Chairman. But I just want to say, I guess my comfort level would be not something that would be perpetual. And I'm not talking about what we do today. I'm talking about later, whether that's next month or the month after. I'd be looking for more at maybe an annual filing. Things change, events come, events go. And the fuel surcharge, we have a lot of history of doing, and that works real well. We don't have a lot of history of this. We've really only been doing it a year. We did it piecemeal. Now we're trying to get some more order to it. I think at least in the next year, we should just approve a year's worth of events. That's my feeling. And so we know the times. It's going to be a lengthy order because there's going to be this big part that's just got all these, every event listed and the times and all that. But I think that gives a certainty that doesn't leave any interpretation. And then we can revisit it a year later. And then maybe we go to a mechanism, or maybe we just amend that list of events, amend the times, and the actual surcharges themselves.
So I have a similar view as you, that it should be an annual order and done in connection with our statutory obligation to annually, I think it's in April or whatever, we've talked about doing, are we going to grant a CPI on the last industry rate? And we also would, at that same time, do the annual surcharge. I agree with you because I would prefer an order that has the actual dates, the actual times. I think that makes not only the board and the authority more bulletproof, but I also think it helps the industry say, well, this isn't something that was up to somebody's interpretation. There's, a date in here, there's a time.
Right.
So any disputes, and I'm not, I just kind of hearken to the space you were in at the PSC or PUC, and we wouldn't think that the PUC would issue some open-ended thing where NV Energy gets to decide when the rate starts and when the rate doesn't. I would think there would be a class action lawsuit over the energy doing that. So I think we need to kind of follow that same scenario. Good. Is there, does any member of the industry want to weigh in again? You really don't have to come up and say no.
Just quick. Thank you. For the record, Kimberly Maxon Rushton with the law firm Cooper Levinson, appearing on behalf of the Livery Operators Association. I concur with your comments, Chairman, with respect to developing a comprehensive 2025 schedule. That's why I articulated the F1 dates, because that's what we were thinking was the objective. If you're going to limit today's action to just the 2024 F1 race, then what we would respectfully request is that, again, consistent with what staff is recommending, that the start date be at 1 a.m. on the 21st. That's the Thursday. People will be coming in town for the first practice session, and then ending it at noon on the 25th. People will be checking out. That's the checkout time. And so we think that that adequately captures the time. And so I would respectfully request on behalf of the members of the LOA that that be the order specific to the 2024 F1. As it applies to the full schedule, I would be happy and the LOA would be happy to participate with staff in helping to develop a comprehensive 2025 schedule that we could present to you at next month's agenda, if that's acceptable to you.
Can I ask this question?
Sure, sure.
Okay, so I know you guys have both agreed on 1 a.m. In the interest of people like me who aren't lawyers and are going to get in a cab, would the following language suffice? If the as far as dates and times, if the surcharge started midnight on the day of the first practice and lasted until noon of the first travel day after the event officially ends, does that accomplish what?
In part, Member Decker, so the latter date, the ending date does, but if you started at midnight on the day of the first practice, the practice starts at 10 p.m. So are you starting at, we would talked about 1 a.m. just to have a clean delineation, but if you're talking about an hour earlier, that's fine. I just
I'm
want to
talking
make.
about an hour earlier.
I just want to make
so it's easier for the public.
So starting at,
Starts at midnight on this day.
On the
day of the
21st.
first event, start midnight, the day prior to the day of the first event.
But
Because when you start 1 a.m. to 11:30, 5 p.m., it just gets confusing and it's just easier to remember those numbers for the public, I believe.
Honestly, I believe 1 a.m. is easier for the public. People have a tendency to skew 12 a.m. on a specific date because you've got that, 11:59 to 12. And I think that the public it's cleaner, I think, to the public when it's 1 a.m. on a specific date and noon on a specific date. When you say things like midnight and 12 a.m. is when I think the public gets confused.
All right, so 1 a.m. on the day of the first practice.
yeah, I'm going to concur with you that this is just as an example. This is a problem when ownership of a casino changes. And it used to be at 12 midnight.
Yep.
And then there would be a fight about who's paying the tax at 11:59 and who's paying the tax at 12:01. And so now when you change ownership of a casino, it's at 2:30 a.m. or 3:30 a.m. so that there's no debate about which day you're in.
I agree with you, but the insurance industry does not because insurance policy started.
I know.
Right,
Yeah.
yeah.
But they like the confusion.
Right, yeah. I got you, okay.
Take an extra day.
That's right.
thank you.
Thank you. And to your point, but on a day cert, we're going to actually put in a date.
Yeah, well,
I don't want
I
to
haven't
say
made
the
the,
day.
I haven't made the motion. yet,
Okay,
but
no,
yes, yes.
That's why I'm saying, I wouldn't want to say the first travel day because somebody will say, well, I'm not leaving. My travel day is Wednesday.
My plan was to put both the
Okay.
date and that language in there,
Okay.
so it's
Okay.
clear depending on how your brain works.
Mr. Chairman, for a clear record, Joseph Estunio for the record. Can we identify ourselves when we talk? There's a lot of back and forth going on. I want to just keep it
Oh,
clean.
okay.
Yeah.
Does it not pick us up?
That's,
Okay.
Yeah,
Oh,
I thought
I
that-
apologize.
I thought the electronic record picks up who it is.
Oh, I didn't know that.
Because when we get the minutes, it shows. But
That's news to me. I didn't know that.
No,
I apologize for
no, no
interrupting.
problem. I hope that's the case, because when we get the minutes.
Did our DAG just turn this into a legislative hearing?
Yeah,
No,
right.
just there was public comment and.
Oh, yes,
Yeah,
yes.
and that's where I got a little concerned.
So,
But I apologize.
Ms. Rushton did make her appearance, so. Yeah.
Oh, no.
Any other pre-motion hoopla?
I guess I'd only say that I wouldn't have a problem if this 24-25 draft order came to us in November to give
Mhm.
enough time to really work the whole year out and have time for the industry to go over and sit down with the administrator and staff and exchange ideas and that sort of thing.
Yeah, I don't,
4 weeks it goes by real quick.
you know, I concur. I don't think that there's a press to have something in place for F1. There's not otherwise a press till spring. Unless we were going to do that. Huh?
March Madness would be. the
Yeah,
case.
right. But,
Well, the Super Bowl probably, and then March Madness.
and
Not
then,
if you had your way, though.
yeah, and
Right.
national finals, really. National finals is in
Right.
December.
Yeah, we got
right?
national
Well,
finals, we got New
I'm
Year's.
gonna weigh in. We don't have any reason to believe that NFR is a problem at this
No,
specific point in
I
time.
agree.
Yeah.
I agree. And we have no statistics
Right.
to support that.
Right.
So we
I don't
have to-
even know if the agency has one complaint on it.
Yeah, no, and I concur. And I think that was Vice Chairman sort of point. Okay. I think we're at a point to take a motion.
You want to give it a shot? Or you want-
You give it a shot. You've got a lot of notes there.
All right, I'm going to propose that we approve a $15 surcharge, special event surcharge for the F1 event that would start at 1 a.m. on Thursday, November 21st / the day of the first practice, and lasts until noon on Monday, November 25th, the first travel day after the event officially ends.
Second?
Before I second, I had a question. Is this applicable to, should the order reflect what zone this is applicable to? It's not applicable countywide, is it?
So my point was going to be, yeah, and otherwise incorporate the terms of the previous F1 order, and then that'll give staff enough guidance on what to write and deals with zones and all that other business and signage and.
So with that modification, I would second the motion.
Good with you, Member Decker, that
Yes.
you got amended before there was a second?
Yes.
Okay. Any further discussion? All those in favor signify by saying aye.
Aye.
Any opposed? None. Okay. That handles agenda item 5 for the time. Takes us to agenda item 6, which is an application from the Livery Operators Association for an advisory opinion relative to NAC 706497 and its application to employee drivers also acting as independent contractors or lease taxi drivers for the same certificate holder that employs the driver. Before Ms. Rushton and others present, just want to lay of the land for the board members and staff and the AG's office, correct me if I'm wrong. Just about what our procedures are for an advisory opinion, unless everybody's going to tell me they read them. So our procedure, and there's many flavors of ice cream that have been adopted pursuant to 233B120 by different agencies. But we have the following one of those flavors. Today, what this is agendized for is for us to decide whether to grant or deny the petition, which is, yes, we'll give you an advisory opinion, or no, we won't give you an advisory opinion. It is not to issue the advisory opinion. The issuance of the advisory opinion is then goes through a process where each of us is allowed 30 days to give comments to the administrator on what we view as guidance. And then within 60 days, the administrator, with assistance from the Attorney General's, if the administrator desires it, brings back to us a draft opinion to vote on. And then if we need additional time, we can say we need another 60 days because the draft order doesn't incorporate what we desire. And that's the procedure set up by NAC 706-980 through 988. So I didn't want you to think we were going to be drafting an opinion up here today. That process will go back into the agency, and you will each be allowed, without sharing with the other, because we're not supposed to deliberate, what our guidance or thoughts are. Yes. You have,
I'll ask you later about that procedure.
okay. Whether you like pistachio, which was
Yeah, right.
adopted by
Right.
some, yeah. So with that in mind,
Should I make,
oh, yes, I'm sorry, we have a 281.
I do. Pursuant to NRS 281A 420, need to make a disclosure that a lawyer in my office is currently representing Willow C. Bell on an unrelated matter to this. I don't believe that it affects my judgment on this matter, and I do not receive any pecuniary interest in that representation of the Willow C. Bell entity. So I'm making that disclosure for anybody to comment or whatever.
And is it your intention to participate?
It is my intention to participate on this matter.
Unless the Attorney General's office disagrees, I believe that disclosure is acceptable under 281A 420.
Not at this time, but I'll look into it. And if we need to take action, we will at a future date.
Okay. Proceed.
Good morning. For the record, I'm Kimberly Maxon Rushton with the law firm Cooper Levinson, appearing on behalf of the Livery Operators Association. Joining me today on behalf of the LOA is Mr. George Balaban on behalf of Desert Cab and Virgin Valley, and Ms. Cheryl Gibbons on behalf of Whittle C. Blue and Bell and Henderson Taxi. I'd like to begin by saying, truthfully, we hope that you do not take a position on the advisory opinion. We do not think it's necessary. We believe that the law, as expressed in the statute, is very clear. We worked on the law, the LOA did in 2015, to promulgate the ability to do lease agreements and to enter into lease agreements with independent contract drivers. We thereafter participated throughout the course of 2016 with the TA in promulgating the regulations. And we believe that the regulations and the statutes as they currently exist allow a certificate holder to employ a driver on certain days of the week, and on other days of the week, that driver can be considered an independent contractor and lease a vehicle. That has been a practice that has been in place since 2016. And as the operators will tell you, it's been quite effective. Effective operationally, effective in terms of affording the drivers flexibility, and most important, the protection of the traveling public because of the fact that it gives the certificated carrier a better opportunity to maintain an oversight of the hours of service and the type of customer service that that driver is specifically providing. I'd also note the fact that it is not uncommon, and I think you're aware of this, for employee drivers in the taxi industry to also serve as independent contractors for the TNCs, Uber and Lyft. That's clearly authorized. And so for those reasons, again, I think that there is support for allowing or for continuing the existing practice that has been in place since 2016. What I'd like to do, Chair and members of the board, at this time is turn it over to Mr. Balaban to give you just some practical understanding as to how this works and the benefits of it.
Good morning, George Balaban with Desert Cab. So we when we began leasing, we started rather slow in our fleet, just a small number of vehicles. So as the leases filled up, drivers came in that wanted to lease from us. We had no leases available. We said, we'll hire you as an employee and you can be number one on the list that when a lease opens up, you can switch over. So we had advised those drivers when they come in, we're going to give you a referral slip. When you go down to TA, get your TA card, going to work for Desert Cab, you should ask for your lease medallion certificate as well, so that when that opens up, you can switch over and become a lease driver and not have to go to Taxicab Authority again to reapply, change your card over. So that is how we began, and there was no issues with it. As time went on, we found that we got out of, well, fast forward to the COVID and after COVID, we found drivers as they came back to work for us, they were wanting to work as employees, a lot of them, a minimum number of days to qualify for benefits, health insurance, all the things that you would want to do, which is, when a cab driver, you drive 12-hour shifts, you can accomplish that in 3 days, 4 days. So now you have the rest of the week. Those drivers are going to leave the industry and go lease somewhere else to go drive. And we told our drivers, you don't need to go lease from Uber and Lyft. Lease here, drive your 3 or 4 days a week. You don't have to lease from us for a whole week. We'll have some cars. We'll lease it for you for a day or two. So again, those drivers that wanted to do that went down. They had never been lease drivers. They were employees. They went down, got their lease medallion certificate on their TA card. They would come back and lease from us. Fast forward, every time a driver came in to apply to work at all for us, came to the door, regardless of whether they were an employee or a lease driver, we would tell them, get both when you go to the TA, so you have them. Oh, I'm never going to be an employee. I'm never going to be a lease. I said, it doesn't cost you any extra money. Just get it while you're down there. So they have the flexibility. Again, from where we were standing, my feeling was that when I have a driver who's coming in and is an employee for me or has leased for me, when they leave the industry to go lease from somebody else, I have no idea how many hours they're working, driving, or whoever else it would be. So when he comes back to drive his 4 days as an employee, I don't know if he drove 3 days for a TNC and now he's tired, he's worked too many hours. But if he's leasing internally from me, obviously I have electronic trip sheets. We can track all of his hours. Also, the people that are my employees, if I'm going to have someone who's going to lease from me, I have a known quantity. A driver who's been an employee of mine, I can look at his employment file. Has he been a good cab driver? Customer service, all of that. I can put that person into a car leasing from me versus just somebody coming in off the street. So again, it's just a win-win for us as far as the flexibility goes, for the safety of knowing who the drivers are. And currently, for them to have to choose one or the other, that's not what's going to happen. He's going to be an employee, and then he's just going to go lease from Uber and Lyft. And again, we've gone through all this surcharge and all these different things we're doing to try to get cab drivers to stay in the industry, and to now somehow interpret this rule to say that they can't lease from me because they drove for me as employee for 3 or 4 days. I don't think it doesn't accomplish anything. The concerns of, like, the Department of Labor or somebody that would say, well, you're doing that to try to avoid overtime. Cab drivers are exempt from overtime, so it doesn't apply. It doesn't change anything with minimum wage or anything. It's that your wages are paid to you based on the hours you work as an employee. So moving him into a lease doesn't somehow save me on the minimum wage or anything. Again, it doesn't change on the overtime for me to move him over there. So there's not any angle that we're getting around by trying to do this. It's purely something that we're offering to allow cab drivers the flexibility to stay cab drivers and stay in our industry. The idea that guys that are working even full-time, 4 or 5 days a week, when a big event comes and it's a day off for them, they could either come drive for me as an employee, or if we don't allow them to lease, they're going to go drive for TNC on that day when it's busy, their day off, because they can surcharge and make money. But again, if they can lease from me on that day, they're going to stay in our industry, especially now that we sometimes on these busy events even have surcharges so they can make money. So that's why we do it, and we feel that we should be able to continue to do it just for the convenience and the safety. And I don't see any downside at all. The Taxicab Authority knows where the driver is. He's either driving as an employee for Desert Cab or he's leasing from Desert Cab. When they pull him over, the medallion on the side of the car is either an employee medallion or it's flipped over and it's a lease medallion. If it says lease medallion, he's going to have a copy of the lease with him. So it's, again, I would think from the TA's point of view, it's even better because they know where the driver is. He's either an employee or a lease, and they know that when they pull him over.
Well, Cheryl Gibbons on behalf of Whittlesey and Henderson, I agree with everything that Mr. Balaban has stated. The only difference between what he has stated and how we operate is that we did not actually start leasing until the end of 2017. And when we started in the beginning, we told drivers, go down and get, what was it, a rubber stamp, and it said independent contractor, which they would put on the TA permit, which meant that that driver could either be an independent contractor for Whittlesey Blue Cab or a driver for Whittlesey Cab. So we moved even slower than George, that we let people stay on as employees and lease a day or two a week to see if they liked it. And we did this for several months before we then said, okay, we're going to offer more leases. You need to choose. You can be a full-time employee and lease on your 6th day if you want, or be a part-time employee for 3 days a week, 2 days a week, and lease the other days, because we offer different lease rates for however many days you're going to work. And it is proven to be instrumental in having the ability to have drivers work for me versus going over and working for George, or going and working for the TNCs, because they know how our management operates. They're working as an employee of mine for a reason. They know they're going to get a good vehicle. Chances are, if their vehicle isn't driven by another employee on that same shift, they're going to get that same vehicle that they can lease that they drive when they're an employee, and simply just flip the medallion. So it's worked out very well for us. I can't speak for anyone else that does the leasing in the industry, but I just don't see how it has proven to be a negative. It has helped us keep our drivers in the industry. We know how they are with customers. We know how safe they are. And we know how many hours they've been on the road versus them driving for me either as an independent contractor or employee, and then driving for TNCs when I have no control and no option to get that information.
I do. I have the same question to either Kim or George, asked two different ways, but it gets at the same thing. I think I'm going to go with, if the law is clear, you stated the law is clear, why are you requesting an advisory opinion? And the alternative question would be to George. You said you want to be able to continue to do it. Why can't you continue to do it? And I guess I'll let Kim answer that same question.
In response to your question, Member Decker, and for the record, Kimberly Maxon Rushton on behalf of the LOA, there was a concern by staff.
Okay.
And so we
So the
thought-
agency has a concern?
Yes, sir.
Okay. I do have two questions I'd like to put on the record to the agency, if that's all right. Mr. Administrator, for a driver to get a permit, do they have to be sponsored by an employer?
Yes.
Okay, so theoretically, in order to have a permit to drive a cab, you have to be an employee of a cab company.
Correct.
Just want to put that on record. Second question to the agency, could a driver work for two certificate holders?
Yes.
Okay, all right, thank you.
A permitted driver.
Right.
Member Decker, what was your first question?
First question is, in order for a driver to get a permit to drive a taxi, do they have to be sponsored by an employer, a certificate holder? Do they have to already have a job with a
Whether
certificate
employee
holder?
or less.
Because the idea that,
Your question is as to an employee, not a lessee.
no, my employee is as to an individual. Whether I want to be a lessee,
Or
a lessor, or a employee, I have to go to the TA and get a permit to drive a cab. I cannot get a permit to drive a cab unless I am an employee of a certificate holder.
so stated differently, just for.
No, yes.
For administrators. Can't take the test, can't get a permit unless you come in with a piece of paper that says, I have been employed by certificate holder X, or I am going to lease a car from.
I can't just lease a car from a certificate holder and drive it as a cab driver without a permit,
That's right.
Correct.
but I can't get a permit from the agency unless I'm an employee of a certificate holder.
Right.
That's correct.
Well, no, wait.
No, that is not 100% accurate.
Yeah.
You cannot obtain a permit for either lease or employee without a referral from a cab company. You could never have driven a cab before as an employee and come in and say you want to lease from Whittlesey, and I would send you down with a referral.
Gotcha, okay.
So you don't have to be an employee first.
Right.
All of this shifted when the former administrator had decided to limit and say it was one or the other, that you couldn't do both. You couldn't be an employee and an independent contractor. So if a driver wanted to switch, he was required to attend the safety class, obtain a referral. So if you were an employee of mine and you decided you were going to switch to lease, you had to attend the safety class, I would give you a referral. You would go to the TA, you would get your TA permit switched over from Whittlesey employee to Whittlesey/lease. Then in a month, if you decided, you know what, leasing isn't for me, it's slowing down, I want all the protections of minimum wage, being an employee, you were then forced again to go to safety class, get a referral from me, and go into the TA and have it switched back from Whittlesey lease to Whittlesey employee. We found this to be cumbersome. It really irritates the drivers because every time they were switching a permit, they had to pay a fee as well. So we had then approached the administrator and said, why can't we go back to the way it had been since 2016 for our company 2017, where it was just a stamp that was put on the permit that said independent contractor, and it would say Whittlesey as the employer, knowing that that driver could be an employee of Whittlesey and or an independent contractor from Whittlesey, albeit not at the exact same time, but could not go to Desert and be an employee. He would have to switch his TA permit to a Desert employee status. That's how we got to this point today.
Gotcha. Thank you for destroying my.
Yes, thank you.
No, but that's good enough. That's good enough. I wasn't aware that you could
But-
get a permit or lease, but you can. So, okay, that's good enough.
You should have.
No, I don't.
So follow up on that. You don't really have a dog in the hunt, though, over what the piece of paper looks like, whether it's a rubber stamp or it's two pieces of paper.
No.
You don't have a dog in the
I
hunt.
don't.
You know, I don't have strong opinions one way or the other on this.
No, do you have any questions?
Oh, questions.
And let's handle the questions first.
I don't have really any questions. Well, I do have a question. I'm sensing from all of this that staff has changed its interpretation on this after reading the regs. And my question would be, what is the policy reason for that, or is there one?
Because of NAC 706-497. And that, I can read that if you would like me to.
No, it's just been, it is your, I don't think you need to read it in front of us, but
Okay.
well, if that's what you want to do, I just wanted to know, you are interpreting, to the Vice Chair's question, that authority is interpreting that regulation to prohibit this.
Correct.
Okay. Thus, the issue. Okay.
So tell me
Was
what.
that?
We're good.
Okay, yeah.
So tell me what.
The way I look at this NAC is that an employee cannot lease from their employer. If they're an employee and they want to be a leasee, they can go lease from somebody else, but they can't lease from their own employer.
It's specifically, what sub 3 says is except otherwise provided in NAC.
Yeah.
A certificate holder may not enter into and then sub D, lease with an employee of the certificate holder concerning a taxicab registered to the certificate holder. My question, I have one more question. Here. And this would be to Kimberly, if you know, is there a legislative history on that? And do you know what it is and what it accomplishes, as George mentioned?
So in response to your question, Member Decker, for the record, Kimberly Maxon Rushton, that specific language was adopted as a reg in 1988. We amended it in 2016 following the 2015 session, whereby we passed the legislation that is now the controlling under 70688.396. What the attempt was, and perhaps it's linguistically challenging, was to create, as you see at the beginning of subsection 3, except as otherwise provided. It was to really have a delineation between the standards applicable to an employee and those applicable to a leased driver. But even if that exemption language still doesn't get you there, what we would submit is the fact that the action that we're taking right now does not conflict with 497. You're not asking an employee to lease from their certificate holder. The employee is an employee on those days, and on other days, he or she is an independent contractor. So that to me is one a important distinction. The law as presented before you defines specifically what an employee is. It defines what an independent contractor is. The law says you cannot lease to an employee. We don't disagree with that. But on the days that they're leasing, they're an independent contractor. They're coming to Desert Cab, to Whittlesey Blue as an independent contractor and asking to lease that vehicle.
So basically, you're saying that other than sub 3, that scenario that you just described is otherwise provided for in NAC 706 to 706.5551 to .5569.
Yes, sir. So in 2016, the industry spent an extensive amount of time working with then Administrator Scott Whittemore to develop the lease agreements, the standards, what the expectations were specifically. And as you can imagine, Member Decker, it's a fine line because they're independent contractors, but yet we still have safety obligations and oversight as certificate holders that need to be maintained in order to ensure the safety of the traveling public. So what we did was, again, carve out the exception language so that we would draw a distinction and then refer for those instances in which there was a lease agreement or a lease driver, they would look at the section 551 to 5569. So
Sure.
it was intended to basically to carve out an exception to this specific regulation. But even if you do not believe that those other regulations give you the authority to do this, what we would say is that, again, it's not an employee that's leasing the vehicle.
Sorry.
No, go.
So the second argument would be that the exception otherwise provided for in those NAC sections was most specifically handled in 2016, specifically to allow this practice to occur. Okay. Good.
Do you currently allow drivers to submit a referral for both independent contractor and employee?
Yes.
And I'm confused.
And I can tell you that that as a staff, we have decided to revert back to having both lease independent driver. So there's just one permit. It'll have the employer's name. We just can't implement that yet. We need to write the policy.
So let me make sure I understand what you just said. Currently, you're allowing somebody to come in and say, I'm a Whittlesey independent contractor and an employee, and you're processing that.
No.
Okay,
No,
that was my question.
That's the part that we are not allowing
Okay,
right now. Because of 497.
and only because of 497.
Correct.
In your interpretation.
Correct. I agree with everything that they say. I just
Okay.
feel that because of the NAC that we could not allow it.
And I don't want to put words in your mouth, so I want to make sure. Do you agree with the exception that Ms. Russian just talked about? That's the purpose of the exception that's written into the statute.
If I may.
Yeah.
So legislative history. The only addition in 2016 was paragraph 4, which included the lease provisions of an independent contractor. We believe it's very clear that there's a difference in the statutes between an independent contractor and an employee. And that's our issue. We want them to have their drivers. We want them to make it easy for their drivers. It's just that we know that back when the statutes were created for leasing, they're supposed to be drafted after what the NTA does, Northern Nevada does. And
Which is what?
they don't allow an employee.
I'm
To
just
drive
making
their
sure that we
home.
have a
Yes.
record here is.
So then we have an NAC that we drafted that's a little different than the statute from Northern Nevada. Can we do that? I don't really think so. Plus, it's so poorly written. In my opinion, it is safer to have the board have a discussion with the industry than for me to tell this administrator that, yes, we can do this.
So our purpose is to benefit the public, right? This board's purpose,
Yes.
generally.
Yes.
So what, in your interpretation, is better for the public versus what is not in the best interest of the public?
I believe that Mr. Balaban hit the nail on the head when he said that they contracted the hours. They have more contact with the driver. I believe that that is creating a more safe environment for the traveling public than not being able to track how many hours a driver is driving for one company and to another company and to them. And so I think what Mr. Balaban and Ms. Gibbons is saying is correct.
But one other question,
Yeah.
sorry,
No,
some follow up on that.
Mhm.
So on the flip side of that, though, that none of this stops them from going and being a TNC driver on their days off, right?
Correct.
Okay. So I just want to make sure that's in the record, though, too. Okay, all right, that was it.
So, Mr. Administrator, so essentially you changed the policy from allowing it to not allowing it, correct?
Yes.
Okay. How much notice?
Not just that, actually, you are just following the policy that your predecessor had put in place.
Countering.
Yeah, you changed it.
He's changing it from being allowed to not being allowed.
I thought Administrator Armstrong had gone down this road as well.
He had it originally,
But we
yes.
convinced him.
And then
Oh,
we convinced him to go back.
Okay, very good. That I think is an important part of
Yeah,
the record,
I believe
okay?
it is.
Is that Administrator Armstrong for a period of time was following what you're following now, then he changed it.
He discussed it or he actually changed it?
He, for the record, Kimberly Maxon Russian, he promulgated 2 policies.
Yeah.
And sent them out. And
He actually issued written,
policies.
direct
And then
policies.
we objected to them and then submitted an application so
Okay.
that we could
No,
appear before
instead,
you.
yeah, not a reg.
Not a reg, a policy.
A policy.
Saying we couldn't. do
Well,
Saying we
no,
could
no,
not-
I get that. I'm just saying if it was an actual reg
No, it was
versus,
not.
okay.
Well,
His interpretation of
It is, and I'm gonna say that there's case law that says that and you can disagree with me, but there's case law that says the administrator of an agency has the right to do that. However, I will ask, how much notice was industry given that the policy was gonna reverse?
It has not been noticed yet.
So it hasn't actually changed or it hasn't been noticed?
It's changed, but not noted.
Correct.
So Member Decker, to your point, and this may add some clarification. Mr. Balaban sent a driver down, driver was denied. That probably would have been the cleaner mechanism to get this up to you. I mean, truthfully speaking, it was a denial of a driver permit. We could have elevated it that way and not have to go through this exercise, but there was a lot of dialogue. And we believe, the members of the industry, that through those workshops in 2016, that we did clarify the distinction and everything. But I will leave you with this. Regs can always be deviated from, and for public policy purposes, and you have a specific reg. So if you construe 497 to in any way limit the ability, but yet you like the policy for the reasons articulated by the industry, then fall back to the deviation, and then we can clean it up if we need to. I don't think you need to go that far, but I just hate to go through the exercise of an advisory opinion when I believe that seems like consensus that it's a good policy, it works, but staff is concerned that there may be a legal impediment and they want clarification from the board.
Well, here, and that goes into my next 2 questions, if I may. Ms. Webb, what's the statute that's in conflict? Do you know that specifically?
Not without taking my time to look.
Okay, so, but if you could get that to me. So it's in, okay.
Yes, sir. It's in there.
The second thing is, Mr. Minister, you believe that this is good public policy, actually, correct?
I do.
So another alternative would have been to have submitted a BDR language to change the statute that's in conflict to allow this to happen prior to impacting industry and the public with a reversal of the agency policy. Which, to be honest, is what I would have done. But it's your agency. But you're aware of the impact pending resolution of this issue. There's a substantial impact to industry because you can't now do something you've been doing for 8 years or more. Okay.
Mr. Bellman, would you describe what you think the effect on having drivers and recruiting drivers that this change in the policy would have?
They'll be forced to choose one or the other. You can be an employee for me, either full-time or part-time, but then see you on the days that you're not working for me. And unless I'm incorrect, staff's interpretation of the NAC is that they can drive for me part-time 4 days a week, and then they can go lease from George 3 days a week, and now we've got somebody out there that is working 7 days a week, and I have no way of knowing this within our own industry. Much worse that they're going to drive for a TNC for those 3 days, and now I've got a guy that is coming to work for me that has been on the road for up to 12 hours a day, sometimes even more with regards to the TNCs. How safe is that driver going to be on the road? That would be my first issue. And the second being that the more opportunities, the more choices, the more flexibility that we can give anyone, they will want to stay in this industry or come into this industry because of those things. The more restrictive we become in allowing them to only do certain things on certain days, certain ways, when there are no restrictions with the TNCs, it's struggling to try to keep people employed and to attract new people.
Well, literally that's in my notes, that you could use the cab, you could be an employee here and then a leaseholder for a different company. If that is contemplated and allowed by law, I'm not sure what the NAC or the NRS is accomplishing by preventing that person from being an employee and leasing just from George versus leasing from you and then being an employee. So if that's okay, I'm not sure why it's...
Even more by saying they could be an employee for Whittlesey Blue Cab, but I could lease to them from Henderson Taxi.
Right. And if that's okay, then what's that?
Even though we're
law
the,
accomplishing?
it's because it's a different certificate holder.
Right.
So
Stated lawyerly for the lawyers, that would be an absurd result, and so we wouldn't interpret statute or regulation that way.
It's a distinction without a difference. Right. So how does it affect, and again, same question for you, how does it affect your ability to retain drivers?
Well, I don't think it's really changed my ability to retain them, but things really changed for the world, but in the cab industry after COVID. I think a whole bunch of people determined, you know what, there's more to life than just work. So guys that used to work 6 days a week, their employees were going down to 4 days, 5 days, 2, but then I lose my health insurance. Let me go back to 3 or 4. So, they're trying to find that sweet spot. Well, they're doing that, but now they've got some free time and they're thinking, I can go drive for Uber and Lyft and I can make some good money. Oh, well, now I can lease from the cab company on not every Friday or every Saturday, but I can do it here and there 2, 3, 4 times a month and make some extra money. I don't have to split it with the cab company. That has allowed us to keep those people in the industry versus them going somewhere else. So I don't think that person would quit working for me as an employee 3 days a week, 3.5 days a week for his health benefits, but he's not going to work that extra day for me or himself in essence. He's going to go work in another industry because he's not allowed to do it for me, right? So that's where I think it hurts. And to a certain extent, it hurts if somebody comes in and wants to lease from me and I don't have leases available, which happens a lot because we're full. I will have them be an employee and wait for something to open up, which could open up in a couple of days. If I have to put them as an employee and then they have to go through the entire process of going down to TA and switching everything all over again, that person's not going to stay. He's going to go look to lease from somebody else. So
it also doesn't send a market signal to you, I need to buy another car.
Well, it's because I'm out of medallions on the leasing.
Okay. So,
Yeah, so it wasn't the equipment in that case, but we're trying to find a balance between employee and lease, the use of the medallion, so.
and not to,
No, and I think I know the answer to this question, but let's just put it on the record. And it doesn't benefit you to refer that driver over to another company that potentially has those leases or medallions available, correct?
No.
No. It should.
so I'm just going to say on the record that's created today, I'm prepared to grant the petition. And the reason I disagree with you, Ms. Rushton, is that if we deny the petition, we don't resolve the agency's position. And even if you were, well, not you, but if Mr. Balaban was able to convince the administrator, this administrator, to change his position, this is capable of repetition. And to me, this is the quintessential example of when an advisory opinion is necessary. The agency saying, this is my interpretation. The industry saying, this is my interpretation. And it's our call to weigh into this and say, this is the correct interpretation. To your point, Member Decker, the old adage, at least in my biz, is don't ask the legislature to do something if you can ask the agency to do it. And so before I'd ask for a BDR and maybe never see it and suspend this issue for at least a year.
Well, I am asking the agency to do the BDR.
No,
That's my point, is I'm asking the agency to
but
do
my
it.
point is
Yeah.
that will not solve this issue
Today.
for
Today.
over a year.
Well, however, there's a big difference between, and I say this from personal experience, if the law is inconsistent with good public policy and the interpretation is unclear, the administrator has the authority to pend a reversal of the agency's position pending the outcome of a BDR submitted by the agency.
Correct.
To
He
clarify.
also, oh, is it only on a BDR?
Well, it's on any issue really, but
He could also do it on the fact that we grant a petition.
true. That's true, but instead of asking industry to quote the BDR, because it benefits them and the public, since the agency is friendly to this proposal.
So I'm not in disagreement that he could ask for the BDR.
Right.
But I also think that should not be a grounds for not granting the petition.
No, totally different issue.
Okay.
I'm not saying that.
Because granting the petition and processing it, so I could see the legislature saying, board resolved it. We're good with that. We don't need to change. We don't need to process this BDR. Or they could say, as is their prerogative, Governor, you should get rid of those 4 dudes because they're making bad decisions. And that's, the governor and the legislature's prerogative. But so my view is that the record that's before us, we should grant the petition. If the administrator wants to take that as a signal that he might want to suspend something, he can do that. That's his prerogative. But Ms. Rushton started this in a way which took me aback for a moment. Don't grant my petition. And when great strategy, but I think wrong direction given the record I see in front of me. So I'm just going to say I'm in support of granting the petition.
Chairman.
Yes.
Right. So, and correct me if I'm wrong, Kimberly. So I've read the transcripts from the hearings that dealt with the prior administrator's rulings. And I thought they solely dealt with, can there be one permit for an employee and one permit for a lessee? And we are in the process of changing that, so yes, it'll be just one. Because that seemed to be a big deal with the board, and we want to get that fixed. I did not see anything in the transcript about can an employee drive for their own company, also as an independent contractor and an employee at the same time. I don't remember any of that. But that said, I have contacted the Legislative Council Bureau about this. It's way past time for BDR. And we're not even in that window. But we could do a temporary change to the regulation. And that will be good through November 1st of next year, so a year, while we try to get one through, because I was told that the legislature won't even look at our new reg till after the legislative session. So we have considered doing,
But,
the new reg, the temporary reg.
but that could in fact be part of the advisory. That could be an outcome of the advisory.
Yes, and I
Is
wanted to
that-
let you know.
That absent a change of this regulation, you can't fix it. But I think the first question is Ms. Rushton correct in her interpretation that the except as otherwise provided clause is intended to say, go look at these regulations, they allow leases, and then the provision here in 497 that says you can't, that a person may not concurrent is subject to that process. So I get the legal argument, and I think that's one worthy of looking at under rules of statutory construction and whatever the legislative history is.
Yeah, and if I could just clarify, I don't actually find a statute that's in conflict. It's just this regulation. It's just 706.497. Is that correct?
Yes, sir.
Yes, okay.
Yeah.
So essentially, if between .5551 and 5569, there's a provision that that contradicts or provides an exception, then there isn't really an issue. I just have to review those. Gotcha.
Any further questions in the scope of the petition?
No questions?
Are we in a position to entertain a motion?
Go ahead.
I would move that we grant the petition for advisory opinion.
Second?
I'd second it.
Then moved and seconded. Any further discussion? You have a question?
I do have a question. Right. So with respect to, now we do our legal work, is
Well,
that?
you're assuming that this is going to pass, but okay.
Yes, I'm assuming it's going to happen. So I just want to know if it's TA and the DAG, TA, what your order is going to be regarding that. If it can
So-
encompass that.
So we don't need to reach that issue, in my opinion, Ms. Webb, because the regulation themselves says if you want to ask the DAG for assistance, you can. You can ask of the Attorney General's office what assistance you want them to provide, or you can say, cool your jets, I'm doing this on my own. That's my
I just know
interpretation.
what his jet is. So
Huh?
I just know what his jet is. So I'm
Okay.
going to ask for his assistance.
But I don't know if anybody disagrees with my reading of the regs. I think that, and that would be typical of every other state agency of which I'm aware of, where there are not on-staff lawyers. So is that enough guidance?
Yes.
Okay. Any further discussion?
Mr. Chairman, I'd like to amend my motion. I'm not
Okay.
exactly sure how to go about this. I'd like to move that we grant the petition for advisory opinion and direct the administrator to cease any change of interpretation until such time as the board has ruled on, issued an actual advisory opinion.
I don't think we have that authority.
Unless somebody's going to point to me, I'm going off of memory as well. I appreciate what you're saying. I believe that that's a statute, if I recall. that statute, it's not, we're not part of that scheme. We're outside that scheme. I'm gonna, not suggesting this is any, if he did it and we didn't like him doing it, our relief is to remove him from office. That's literally how that scheme works. And then the governor has to appoint a new, or the director has to appoint somebody to replace him. I don't think that that statute allows us to tell him to do it. I do think that he can interpret however he wants
Okay.
to the action we take today.
I get, okay.
Yeah, I'm worried about us, I'm worried about the whole motion being defective because we did something we don't have the power to do.
I also, having sat in his seat, want to be very clear that it's his agency and that we're advisory in nature and we don't tell him what to do. Theoretically, you're right, we could fire him. I think we changed that anyway, right? Or we tried
We
to.
asked to change
We
it,
asked
but
to
they
change
didn't.
it.
But
Because I'm
we've
not a
never
fan of
gotten
that
relief-
either.
We've never gotten relief on it.
Yeah, I mean, it's your agency. I would pose that if you need help with alternatives other than reversing course, I'd be happy to provide, but I don't think the board can direct him to do anything.
So can we go back to your original?
I guess we go back to the original motion. I mean, my thought was, is, we talked this out. I'm more focused on the reg and I wasn't looking to
Mhm.
amend a statute. But what I'm hearing is we have an interpretation from the administrator and now that interpretation is being changed. That is what we're trying to prevent until we have opportunity to discuss it in rule.
I think what we have is periods of time when they have allowed it, periods of time when they've questioned it and not allowed it, and now we're back into and then it went back into being allowed, and now we're into the not allowed. But that's my capable of repetition.
Yeah, I would add that.
And
Dawn-
therefore, that's the quintessential, somebody's got to be the ref here.
There's two things that I would point out up to Don's point. One is if that had been taken out of the reg when it was last handled in 2016,
Yeah.
we wouldn't be having this conversation. That's on you guys or the administrator at the time. And the second thing is the administrator over here owes industry notice from a legal standpoint, not being directed by the board, but it would generally not be appropriate or
Kosher.
legal for him to reverse course without notifying industry, and he stated he hasn't. So maybe that's a period of time that he can justify suspending this. Yeah.
So I think we've given some suggestions of potential course of action.
And I guess I have a procedural question. If we grant this petition, what happens next besides the advisory petition being
So,
drawn up?
so pursuant to the regulations as I read them, each board member has 30 days to submit to the administrator. This is my personal, not the board, my personal member, not a board action view of how this should be interpreted, which you can you can choose to exercise or not. And then there's a 60-day period for the actual advisory opinion to come back to us. Here's the form of the advisory opinion. We hold a hearing on that and decide, yes, we're going to issue this, or no, we're not, or make this change and then issue it. Or if we think it's wrong or we don't like it at all, we can take up to another 60 days to vet that process back and forth with the draft person of the opinion.
I want, to have that conversation so that we all know what our timeline is after this.
My view, my thought is we certainly know the industry's position in writing. It sounds like this is not like on the fly at the agency. It sounds like they've thought this out, what their position is too. So
And
we're
I
going
guess,
to throw up the ball and
Okay.
I guess one more procedural question. Are we is it required that they do the notice as to the change in the policy?
You could say legally, it would not be upheld if they didn't. If you get all the way down through, so there's case law, there's 233B would say some kind of thing about it. So that's not something that is done for many reasons, including it's not statutorily justifiable. There's some case law that says you've been misinterpreting the law for 20 years. You can't just reverse course on it. You need to go change the law. There's all kinds of legalities, but not giving notice to industry before reversing is not something that can be upheld.
There's one last discussion point that I want to give whoever starts working on this. I'm just throwing this out there. I've not analyzed it, but there are, to my recollection, 2 or 3 Nevada Supreme Court decisions on independent contractor leasing taxi cab in this space. I don't know that they affect the outcome of this opinion request, but I think we need to know whether they do and whether there are any unintended consequences by the opinion we issue based on liability to independent contractor or certificate holder created by the result that we consider. That's the only other kind of moving part I see here. So if there's no further discussion, the motion that is before us is to grant the petition, nothing more.
Correct.
And that's been seconded. There's been discussion. Any further discussion? All those in favor signify by saying aye.
Aye.
Thank you. Thank you. Agenda item 7. Minister.
Thank you, Chairman.
And you can, unless board members have questions, you can just hit the 3 or 4 big highlights you want to consider.
Sure. First of all, I wanted to talk about the revenues per trip. I believe that a big reason for that going down is the fuel surcharge fell off. So I believe that had a big impact. The lease decals between 23 to 24 is up almost 600. That's just a pure indication of where the industry's going with leases compared to the employee drivers. From last year, the monthly combined trip comparison, we're up about 31, almost 32,000 trips. So I think that's a number that's indicative to what's been happening in Vegas. The medallions are still the same. The lease decals by company, we're at 1,669. I want to get into the agency stats just a little bit. You can see our citations are up quite a bit. I think there's a couple of reasons for that. Again, we have a couple of employees that are in FTO training right now. You'll see that the impounds are down, but that's because the module and the FTO training that they're in. Right now, they're doing more of the citation part of it instead of the impound part of it. But I think from July to this last month, I think we went from 67 to 85 citations. I wanted to point out, Member Decker asked me, or we discussed at the last board meeting about the amount of citations that come in and just are taken care of at the counter. They come in, they pay their citation, and out the door they go. They don't go to a hearing. And we're 58 out of 63 is where that happens. That makes me believe that my guys are doing a great job out there and hitting what they need on their citation. Accidents, not too much of an increase from last month, 313 compared to 302. our assaults went up this last month. The complaints are up quite a bit again. Lost property, we had 130 incidents of lost property compared to 99 last month. So when I had discussions with the industry, when Curtis Mell and I went out and talked with them, I talked a lot about the lost property. I think they all have good policies in place to handle lost property, but for whatever reason, we had a lot of lost property calls this last month. Dispatch events, we were up 917 from 842 last month. The citation violation report in July, we had 77, we had 91 this month. Again, I think a lot of that has to do with our training that we have going on with the new officers. And just so you know, we've got another officer that's going to be starting in October. So we're going to be bringing on a couple more here in the near future where we'll be in the training mode still. And I think, you know what, I wanted to talk real quick about the inspections. These guys, and I mentioned them last month, but the amount of inspections that they're going out and doing, those guys are just good hard workers. And I know I mentioned it last month, but I really appreciate the job that they're doing. If you look at the numbers, they're about the same as last month. We know how hot it was last month. Again, the start of this month, it was really hot. But these guys are just steady, put their hard hat on and go to work guys. And I just wanted to, again, shout out to them about how good of a job they're doing. So other than that, happy to take any questions that you guys may have.
Couple questions.
Okay.
A couple things. The 85 citations written, are those civil and criminal, or are you just doing the administrative?
Mostly administrative, but we did issue some citations in
criminal?
criminal. Yeah.
Enough that you want to break it out in the stats?
Probably not.
Okay.
I mean, I don't think it's that significant.
Okay.
I will tell you that we purchased a LiDAR, and the LiDAR is out now.
Gotcha. Well, that's a good segue. I noticed that, 58 out of 63 resolved before hearing is incredible. I mean, there was a time not that long ago, I'm sure Marie remembers when you couldn't write a ticket to a cab driver without going to hearing. Like not one would resolve, and now you're resolving almost all of them. That's a great job. And these tickets, 47 of them were safety, comfort, and convenience, which is traffic, which means people, cab drivers violating traffic laws, which has also been an issue of contention because Metro doesn't want to enforce them. And if every running a red light results in a hearing, then it puts a lot of stress on the agency. So great job on all that stuff. On the UPTs, I did want to say that NTA reached out to my officers to utilize as undercover because they feel like their officers are known out in the world. We'd be happy to do that for you guys if you get to the point where that makes a difference. And then the other thing I would ask, and this is the one that's going to put you on the spot a little bit.
Okay.
Is there a plan to merge the two agencies that everybody has been briefed on except for the board? No comments is on too.
No, I'll comment. I know that Director Sanchez has met with some of the industry. It is definitely a topic of conversation. I am not in the decision-making mode on if they're going to merge or not, but it's certainly a conversation which, as you know, almost every legislative session, it is a topic of conversation. So it is being talked about.
Gotcha. Good. That's all I have.
I will just simply add that I don't think that was to slight us, Member Decker. I think that was to prevent those discussions from having to be public hearings.
Gotcha. No, yeah, I'm sorry, that was being flippant, but.
No,
Just if there is one, I'd be curious to know what the plan is. And there either has to be a BDR or not.
I don't think this is any different than the fact that the Sunshine Commission's been looking at this for 3 years now.
Well, it's been about 8, actually, but they.
But I mean, they've
yeah.
actually held hearings that
Yeah, but
I
they,
got called to in the last 3 years.
in the last 3 years, yeah.
There was a workshop.
Well, and I think
Yeah.
I think the outcome of the last Sunset Subcommittee was to revise 706.
Right.
Not
And then-
necessarily to
and
merge
then-
the agencies, yeah.
Any questions of the
I have no
Vice Chair?
questions.
No, sir. I'll ask him what a LiDAR is after.
Other than his
You'll
taste,
find out if you speed down the road.
I have one question. Other than his taste in paisley ties, how's your deputy administrator?
You know, I work with him on that, but I can't get him. I can't get him. Yeah, but he- I'll tell you, Adam has been a godsend to us. Like I said before, I was wearing a couple of different hats, and coming into a new agency, that was a difficult situation. And Adams came in, and he's so high energy that he wears me out.
Anything else reporting wise?
No, sir. Thank you.
Council, anything we need to know?
I don't think so.
Nothing besides.
Any future agenda items, members?
Nope.
Very good. And that completes agenda item 7, takes us to agenda item 8. This is our second public comment session pursuant to Nevada statute. This is on our agenda for the purpose of the board taking comments from the public on matters within our jurisdiction. We may not take action on those matters, but we welcome comments from members of the public. Is there any member of the public present in the hearing room in Las Vegas that wishes to make public comment?
Real quick, Mario Locascio, General Manager, Deluxe Taxi. I heard you mentioned New Year's Eve and New Year's Day.
Mhm.
I hope for special events, we take that in consideration and put it in a subconscious mind. It's just exactly like Formula One. Everything gets locked down. And I know I can speak for our company and pretty sure they have the same problem, lease or employee. Nobody wants to work. So, thank you.
Any other members of the public wish to comment to us? Is there any, seeing none, no further in the room, is there anybody online that wishes to make public comment? Seeing none, that will close our second public comment session. Is there a motion to adjourn?
So moved?
Second.
And moved in second, all those in favor signify by saying aye.
Aye.
Thank you very much.
I'm gonna have to bring more caffeine.
Yeah.
This is
Especially if we're going to do this